So when you compare the Indian rules and you compare with the US rule, there is a lot of difference between here. If they don't do it, what will happen is what I'll be explaining. So if any default is made in complying with the requirements of this section, 24,99,999, it is 400. See, these are the slab rate which we actually go with. Hello everybody, a warm welcome to one and all. I'm Vidhyaashram from the Department of Commerce and Management in Vidhyaashram First Grade College, the Temple of Excellence. Welcome to all the students here in this special session, that is the session number 6, and here I'm going to explain you about a very important document and the procedure indeed. Now when we go with the company formation, you are supposed to understand how a company is being formed or incorporated. When we go for these detail and things about formation of a company and all those things, we are supposed to know the rules and regulations of a country. So when you compare the Indian rules and you compare with the US rule, there is a lot of difference between how the US people, they go with the formation of a company and how an Indian will actually go for incorporation of a company. A quick recall what we have already done, that is how to go with a private company and a public company. Whenever we go for the formation of a private company, we are supposed to concentrate on one certificate, that is called Certificate of Incorporation. But you need to also understand that there is some other company called a public company. Now to form a public company, you are supposed to go with two of the certificates, that is, one is Certificate of Incorporation, as well as you are supposed to know about one more certificate, that is called Certificate of Commencement. Now we'll go with how to obtain a Certificate of Commencement of Business. Now this Certificate of Commencement of Business is very mandatory, that is very important to start a public company. So what is the rules, what is the regulation, what are the schedules, what are the sections, we're going to understand in this session. So firstly, the company's amendment. Now when you go with the amendment, the act, the bills, you're supposed to be very careful when you are writing the sections. The company's amendment, that to the ordinance of 2018, the ordinance of what? 2018, promulgate on November 2, 2018, has inserted new section, that is 10A. The section is what? 10A. The ordinance was passed in the year 2018. If I need to be very precise, it is the 2nd November 2018. So here in the 2nd November 2018, they had a section that is called as the section 10A to provide. Now this section 10A will actually go with to provide for a declaration of a company having share capital before it commences. What is that? The company people should do it. That is, they are supposed to produce the share capital before the commencement. That is, they commence their business or exercise the borrowing power. So they are supposed to first tell the registrar of companies that what exactly and how much exactly they are supposed to go with the share capital. So this is the first thing what the board of directors, the company secretary and the people who are the promoters, they are supposed to produce it to the registrar of companies in the registrar house. Now after that, what really happens is the provision for tune limitations and the penalties on directors. Now here, if they don't do it, what will happen is what I'll be explaining you. A company incorporated after the commencement of the companies, that is the amendment ordinance in 2018, and having a share capital shall not commence any business or exercise any borrowing power unless, now there are some criteria. What are the criteria? The first criteria is a declaration is filled by a director. Who will actually do it? By a director within a period of 180 days. How many days? 180 days he is supposed to declare about the companies, right? Now of the date of incorporation. That is, they'll give a stipulated time, that is 180 days of the company in such form and verified in such manner as may be prescribed with the registrar. So the registrar will actually prescribe that this is what you are supposed to do before 180 days. That every subscriber to the memorandum has paid the value of the shares agreed to be taken by him on the date of making of such declaration. And there is one more, that is, the company has filed with the registrar a verification of its registered office as provided in subsection 2 of the section 12. That is, there is this section 12 of subsection 2. They are supposed to first file it. That is, whether it is filed or it is not filed, you are supposed to check. So these are the two things which they are supposed to do. If they don't do it, they can't actually exercise any borrowing power. This is what they are supposed to be very clear about. See, the rules and regulation of each and every country should be taken into consideration whenever we are making a form of a company, or whether it is a private company or a public company. See, that is why the directors, the company secretary, everybody gonna play a very important role in the formation of a company. I've told you how many directors should be there in a private company, how many directors should be there in a public company. That is minimum. See, maximum they have not actually mentioned anywhere, but they always go with minimum. And for one person, that one person can be a director for at least less than 20 companies. He can't actually exceed more than 20 companies. And I have already told you about the digital signatory certificates and the director's identification number, that is called DIN, which he will be getting it. So he is a person who should actually, he gets all the authority, and he is the person who should go and file the things in the registrar office, the way the registrar have actually mentioned, before 180 days. That is, within a period of 180 days. Next one is the third one. It is, if any default, now there is any default is made in complying with the requirement of this section. Now that is the section 12 subsection 2. If there is any default, now what happens is the company shall be liable to pay a penalty, and the penalty is what? 50,000 rupees. How much is the penalty? The penalty is penalty, right? Now the penalty here will be how much? 50,000 rupees. That is what the penalty will happen. And the officer who is there, right? And the officer who is that particular officer is there, and he will be actually getting a penalty of 1,000 rupees, the officer's penalty. The officer's penalty will be 1,000 rupees, but it will not exceed, but not exceeding how much? It is 1 lakh rupees. 1 lakh rupees. This is what the Companies Act actually goes with, that is 2013 Companies Act, and here we are going with the ordinance of 2018, right? So please understand, and that to the ordinance of 2018, that is 10A, we have the provision. So if any default is made in complying with the requirements of this section, the company shall be liable to a penalty of rupees 50,000, and officer, see, who's that? The officer. The officer who is default, if the officer is default, shall be liable to tap a penalty of rupees 1,000 for each day. For how many days? For each day. That is every day, each day. Each day he is in default, during which such default continuous but not exceeding amount 1 lakh rupees. So this is what the law actually goes with. That is, you can actually see, I'll tell you here, the minute it is a default, you will be getting a time limit. You are supposed to do it within very fast, because you should always have a goodwill for a company. You should never go for a blacklisted company. That's the reason they go with these things. So the company is liable for how many penalty, that is 50,000 rupees. And a person who is the officer who is in a default, he should actually be penalized for 1,000 rupees for each and every day, but it should not exceed more than 1 lakh rupees. Next one is fee structure to obtain for commencement of business certificate. Now, what are the fee structure? Now, please understand, you will never get any information of the fee structure in any of the other videos. Exclusively, we are only giving you for these kind of things, that how to make a student learn better way. Now, here the nominal share capital fee application, less than 1 lakh is there. So, the application fee is how much? 200 rupees. If you go with 1 lakh to less than 5 lakh, that is 4,99,999 rupees. If you go, the fee application is 300 rupees. The same way, 5 lakh to 24,99,999, it is 400. See, these are the slab rate which we actually go with. The same way here, 25 lakh to less than a crore, it is 99,99,999, it is 500 rupees. The more 1 rupee extra is there, that is 1 crore to more, you go with rupees 600. These are the application, that is a certificate fee which has been applied in India. So here, non-compliance, if you go with the non-compliances, and if you have seen the nominal share capital fee application, if you go with the nominal share capital, if your share capital is less than 1 lakh rupees, how much is it? If it is less than say 1 crore and more than 25 lakh, this is 500 rupees. So we have certain slab rate like these things. Now, non-compliance by an officer is default shall result in liability to a penalty instead of fine. So there is no fine, it will be what? Penalty. The penalty will be implemented very soon. And again, I'll be telling you what all the procedure here it is required is. The first one here is the period of delays for all the forms, say up to 30 days, 2 times. Up to 30 days, how many times? 2 times of nominal fees. That is a penalty. More than 30 days and up to 60 days. That is, you have a slab 30 days to 60 days. The penalty is what? 4 times of normal fees. 4 times. Say example, we had 400 rupees. Right? And the slab we have already went with. Now, if you don't go for it, 30 to 60 days you are actually going with it. So 4 times the nominal fees. Now, that means what? Into 4. So you'll get 4 4s are 16. So this is what your penalty is. The same way, for 200 how much it is, for 300 how much it is, for 400 how much it is. Now we have seen that 1 crore and more we are supposed to pay 600 rupees as the fine. If you go with 30 days to 60 days, there is a kind of a thing. Now 4 times into those. More than 60 days and up to 90 days, it is 6 times the normal fees you are supposed to go with. There is nothing called fine, it is called penalty. Then we have more than 90 days and up to 180 days. See, this is what the last one is, that is 10 times of normal fees. And lastly, more than 180 days to 12, it is 12 times, that is the normal fees. So these are the slab rate which really happens. You are supposed to be very careful. The minute you get this incorporation certificate, you are supposed to go for the commencement certificate before the stipulated time. And the directors need to actually give all the clarity about each and every document which the ROC will actually ask for, and then they are supposed to get the commencement certificate. The minute the commencement certificate is reached to the office, now it is your time to start your public company. This is how the commencement certificate procedure will happen, and it's the same way the incorporation and commencement certificate. You are supposed to show all the documents. Memorandum of understanding should be there, memorandum of association should be there, article of association should be there. Then you will actually go for all the incorporation certificates and everything. Then the ROC will actually give you a certificate of commencement. The minute the certificate of commencement is there, now it is good to go, and you can start a public company and you can run a public company with the directors, promoters, shareholders, stakeholders and all. And that is how you people can start the beginning. If you have any doubt regarding this session, please do call us. We are always there to help you. Thank you so much. I'll see you when I see you.